Good morning, everyone, and thank you for joining us for today's session, where we will be looking at a conveyancing review of the year with our regular speaker, Ian Quayle, and I'm delighted to also be joined by my colleague, Robert Kelly. Good morning to you both.
Morning. Lovely. So we are recording today's event. As Stephen mentioned, if there are any questions or queries, feel free to drop me a note. If there are any issues or queries with regard to title indemnity products, then Robert and Stephen are at hand to assist. So what I'm going to do now is scamper through 2022 and look at some of the key issues that I've sort of decided are significant for conveyancers. It's been an interesting year, and a year of two halves, hasn't it, really? In that the start of the year we were buoyant and booming and all was well, and then quickly deteriorated into a sort of an economic catastrophe, which we're still being part of. A number of things, really. Firstly, as far as residential conveyancing is concerned, my view is work and the marketplace is cyclical. Every 5 years or so we have booms and we have times where we're not quite as busy. As far as the market is concerned, there's always a residual level of conveyancing work for firms, and I think as far as residential conveyancing is concerned, we're better placed than most other aspects of legal work to ride the storm. The next thing to mention is that when I'm talking to firms, although they're telling me that their workload is down, firms are still looking to recruit, firms are looking for training, firms are looking at artificial intelligence, looking for product, software, etc., to try and improve services. So I think there is a confidence, a remaining confidence, that the good times will come again, and I'm sure that's right. As far as the position with regard to transactional property work is concerned, there are a number of trends to share with you. Trend number one, I think the professional indemnity insurance market is tightening and hardening. And the reason for that is that we're seeing claims that have arisen during COVID lockdown, during the busy boom periods coming through. So certainly I was talking to one professional indemnity insurance broker that was telling me that they were very concerned about the number of claims. The second thing that's interesting, and I've just had this reiterated this morning, is that claims seem to be developing with regard to poor communication. So remember, communication is a two-way process. It's all well and good if I'm your client, you sending me a report on title. How do you know I've got it? How do you know I've read it? How do you know I've understood it? Imperative that I am asked to confirm those things. It's not for you to go to the end of the earth to make sure I have read it and I have understood it. It's for me as a client to tell you that I haven't read it, or I haven't read it in full, or I haven't understood it. So we change the onus onto the client to tell us there's an issue, rather than us sitting there assuming the clients have received documentation and understood it. So this issue about communication is a problem in connection with claims, and it will grow as we get more and more standardized, as we've got more sophisticated with regard to procedure. There's a danger that we standardize our clients, we standardize our relationship. And I've just been involved in a webinar this morning with a KC who is explaining exactly the same thing, that we do have to be careful to analyze our client's attitude to risk, our client's level of understanding, and we have to make sure that we're transmitting information to that target audience, rather than the concept of all clients being the same. We've seen some interesting case law. We've seen some interesting new statute. We've got the CQS guidance. So there's lots of things that have happened this year that I think are really interesting. And what I'm going to do is quickly take you through them. I always mention useful websites. They're all sitting there, and other than the last one, they're all free and well worth looking at. So do be aware of the websites and the information contained in them. Leasehold Advisory Service has just given some new guidance with regard to fire safety issues and high-rise flats. Leasehold Knowledge Partnership, lots of information there concerning fire safety, defective leases, etc. The Association of Residential Managing Agents and the Leasehold Advisory Service has very useful leaflets about leasehold transactions and the bigger picture. I always mention the RICS website because there is a consumer guide to surveys and valuations, and I've been speaking at a number of conferences recently, and I mention it, and I see people scribbling frantically the details, which tells me people are not aware of the RICS Consumer Guide to Survey and Valuation that provides the client with information about the types of survey and the benefit of survey, basically removing from you the duty and obligation to explain types and choice of survey. So be aware of all of those sites. Again, they're all free to access and all particularly useful. The first thing I want to talk about is the CQS guidance change in May. And having spoken to the CQS lead assessor on a number of occasions, there are some important points that I think to share with you. Firstly, CQS assessors are coming out to see firms, and they're looking at firms to see that they have policies and procedures in place, obviously, but they're also looking at whether or not those procedures and policies are being applied. So if we have money laundering processes, if we're looking at a file, do we see where there's funds coming in from parents, that we've undertaken an assessment with regard to the sources of funds? Do we ensure that every fee earner in every department in the conveyancing team is aware of our policy with regard to money laundering and why it's in place? Do we collect data and then utilize data for reviewing policies and procedures? So I was talking to a firm last week who had originally been a high street practice, then had sort of changed into a firm that still dealt with local clients, but also created a more internet-based presence for attracting and onboarding work. And as a consequence of that, their policies with regard to risk had to change. Their systems with regard to client verification had to change, etc. And more recently, they'd sort of retracted from the internet market and were doing more and more sort of local work with clients coming in to see them, with clients that were sort of close to the firm and the firm's office, in which case, in those circumstances, there was a review of the type of work that was coming in and of the policies and procedures that the firm were adopting or applying to those clients. So I think one of the big things with CQS when you're receiving a visit is to see that you're collating and collecting data and that you're utilizing it in order to review, enhance the policies and procedures that your firm has put in place. Remember, CQS requires an SDLT process for every file. And again, we can drill down that process, and will do before we finish this morning. We need a leasehold procedure explaining the bigger picture with regard to leasehold transactions, and also a procedure so that the client is made aware of the key features of the residential lease. And again, this morning, in the words of a KC, it's not enough simply to provide a client with a copy of the lease and say, read it. We've got to provide explanation. We've got to tell the clients, in his words, the gist of what the clause in the lease is driving at or dealing with. We need policies with regard to land registration to assess why we're being requisitioned. Is there a common theme or thread with regard to requisition, and can we deal with it? Can we come up with policies and procedures, perhaps arrange training so that the requisition numbers of requisition are declining and common requisitions are being addressed and being dealt with? High-rise buildings and fire safety, again, policies. I repeat, the Leasehold Advisory Service has a new leaflet on high-rise buildings and fire safety. The Building Safety Act 2022 imposes additional duties on landowners, landlords, etc., with regard to building safety, of which fire safety is part. The fact that with regards to the Building Safety Act, we've now got reform of the Landlord and Tenant Act 1985 and implied terms into residential leases. Implied terms being imposed on the landlord with regard to building safety management, building safety risk assessment, the transmission of that information to leaseholders and to the building safety regulator, and also implied provisions into residential leases imposing obligations on leaseholders to pay building safety charges, additional charges relating to building safety over and above the standard service charge provision that we could expect to see. So again, we need to make sure that when we are onboarding clients and taking on new transactions, we're being aware of individual processes and procedures that are applicable to those transactions. And it might be, as a firm, that we're not going to take on certain types of work. So at one of the forums, residential conveyancing forums that are kindly sponsored by Stewart Title, one of the discussions that we had in that forum was whether or not we'd be willing to act if we had an unrepresented seller or an unrepresented buyer on the other side of the transaction. The view being with a lot of firms that they wouldn't be prepared to act in connection with a transaction where there was an unrepresented seller. Some firms were saying they might be prepared to act if there was an unrepresented buyer. The important point here is that we've got a policy, we've got a practice that everyone within the firm or organization is aware of. Sources of funds, again, so important that we have a policy that everyone in the firm can apply to each individual transaction. Again, all of these issues, every fee earner needs to be aware of, but if we've got members of staff that are just onboarding clients or dealing with initial inquiries from clients, it's important that they're aware of some of these things so that they can be alive to issues that might require further attention as and when the transaction moves from being an inquiry into an onboarding exercise. We need to do risk assessments with regard to money laundering. So when we're doing a risk assessment, we risk assess the transaction, the client, we potentially will risk assess the other side and their lawyers. Fraud risk assessments, the same thing. Again, as far as fraud is concerned, property fraud is still out there just as much as it ever has been. The fact that we haven't read any sort of horrific reports recently, and we haven't seen anything in the newspapers or on TV about people losing their property to fraud doesn't necessarily mean that fraud has disappeared. Far from it. We've always got to do a risk assessment per file on the risk of fraud. Where we're dealing with a high risk transaction, then we should be putting in measures with regard to management of the file, supervision of the file, to credit the fact that we've identified that this is a higher risk transaction. We need to do transaction risk assessments. So again, I've been looking at some of the issues with regard to what would generate warnings with regard to transactions. A client that we've acted for on 6 previous occasions who bought 3-bedroom terrace properties in the Wolverhampton area, all of a sudden is buying a 9-bedroom detached property in an exotic part of Cornwall. Well, why is that transaction taking place? Where's the client getting funds from? Why has he been buying buy-to-let properties in the Midlands and now he's buying this very expensive property in Cornwall? When we're looking at a transaction, important to ascertain that we are happy with the transaction itself, and we're also happy that we can do the work itself. So again, I was with a firm recently and they'd just done an audit of the sort of work that they were willing to take on, and they were concerned about any sort of transaction, residential transaction, that had an international context. That international context being whether the client was based abroad, whether the seller was based abroad, where funding was coming up from abroad, this sort of thing. So client risk assessments are important on every file. So the fact that we've done a risk assessment in connection with Mr. and Mrs. Smith in connection with their purchase of 2 Acacia Gardens 3 years ago doesn't mean that it's safe to assume that that risk assessment would stay good and stay true in connection with the transaction that we receive instructions on in December 2022. We need policies with regard to managing instructions, making sure that work is properly allocated, making sure that if work is high risk, there is strategy in place for management of the file. We need risk assessments, and those risk assessments need to be under review depending on the type of work that we're doing and dependent on external factors. So National Crime Agency, SRA, and other organizations highlighting a new type of fraud or new aspects of current fraudulent activity. Do we have policies? Do we amend our policies to take into account what we're being told externally and also what we're finding out internally? Key date management, again, important, and not just highlighting key dates, but giving ourselves time to enable us to deal with matters rather than dealing with something right on the final day. Those of you that have heard me in the past will know that I do work with professional indemnity insurers and look at negligence claims. Frequently, negligence claims arise in connection with very good conveyancers who all of a sudden are under a boatload of pressure, who isn't, and who is all of a sudden right at the last moment being required to do something. The provision of an undertaking, right at 4 o'clock on a Friday afternoon that will enable our buyer to get into the property, and we're going to sort out completion on Monday. The search with an adverse entry coming in right at the last minute before we exchange contracts, or the land registry search coming in with an adverse entry and a seller being required to give an undertaking relating to the removal of a notice. This sort of thing. So it's not key date management, but I think it's efficient planning to enable us to deal with key dates during the transaction. Conflict management, again, I'm going to show you before we finish today a real nightmare where a lawyer was willing to act to start with on behalf of a seller and a buyer in a transaction where it was blatantly dangerous to do so. And conflict management is between client and firm, between client, and of course client and lender. Next thing to talk about is the issue of money laundering and red flags relating to money laundering, and making sure that fee earners are aware of the red flags that can arise, some of which I've explained already. So do we make sure that our colleagues that are undertaking transactional property work on our behalf are aware of warning signs? Again, I've just done some work with regard to this, and I looked at legal executives, law societies, all sorts of different organizations that have produced guidance with regard to red flags relating to money laundering. And again, it was quite interesting to see that there were different emphasis depending on the type of organization, but there were some common themes. And again, important that we have a policy with regard to how we respond to warning signs. And again, important that we collate data. So if we're getting fee earners generating red flags relating to money laundering, what are we doing with them? Are we reporting them? Where we're deciding not to report to them? Are we recording what we're finding so that we can assess if there are trends, if there are issues that require addressing? CQS requires an annual sort of review or an annual audit with regard to data. I think that if you're doing a lot of work, that review or that audit should be quarterly to enable you to be able to react and to be able to pivot depending on circumstances and depending on what the data is revealing to you. Property and mortgage fraud, again, we of course are aware of the availability of seller identity fraud. Again, CQS guidance highlights the need to check and verify the identity of conveyancers on the other side of the transaction and to be aware of transaction risk. Again, policy, again, data relevant to that policy, and again, evidence of review. Important, again, that every member of staff is aware of policies and changes to policies too. SDLT, I said I'd come back to this topic and it's so important. Point number one, CQS guidance highlights a basic principle and best practice with regard to SDLT, the fact that we need information from our client as to their circumstances and the transaction in order to give proper guidance with regard to SDLT. So, are we asking our clients if there are any other transactions that are related to the transaction for which we've been instructed? Second bit of information, if there is an agreement with regard to apportionment of purchase price, what is that agreement? And where that agreement will have SDLT consequences, do we need evidence as to the valuation of chattels or fittings that are being paid for separately? Again, with regard to CQS guidance, important that clients are made aware of the reliefs and surcharges that can apply with regard to SDLT. Important that clients understand and appreciate that where information is submitted to HMRC electronically by you, you are submitting information that the client has provided. And therefore, if that information is defective, the client potentially is in the firing line with regard to fines, surcharges, etc. Important to understand and appreciate that where we're dealing with a complex SDLT issue, mixed use property, second homes, this sort of situation, that there is nothing wrong in seeking specialist advice on the SDLT liability that is to be incurred. Further, important that where we are comfortable that we can determine what SDLT liability arises, important that we have on our file or on our case management system how we've arrived at a particular decision or how we've arrived at an amount of SDLT that is payable. Important that we have a file review that shows when we're engaging with the client and we've given an estimate, the estimate with regard to SDLT is correct and is in fact the SDLT that is due to be paid, that we've checked contract and transfer and SDLT return to make sure that the data relating to purchase price is consistent throughout. Again, important that there are file reviews to make sure that that process has been utilized by every fee earner in connection with every file. So I'm not saying a review of every file, I'm saying we need to check individual fee earners to make sure they're complying with policy. Leaseholds. Again, I talk all constantly about explaining the bigger picture, the radical difference between freehold and leasehold ownership. And again, Leasehold Advisory Service, Association of Residential Managing Agents, Leasehold Knowledge Partnership, there's a raft of information that you can link to your report on title or to your retainer or engagement letter, or you can download the appropriate guidance or leaflets and provide them to clients. But it's important that clients understand the radical difference between freehold and leasehold. I can take it further and say clients need to be aware that when having a lease assigned to them or when having a new lease granted to them, the client is committing to an unascertainable cost ongoing, namely service charge. And where we're taking an assignment of an old lease and the old lease has a monetary ground rent, we're committing to an unascertainable ground rent going forward if there's ground rent review provision that doesn't enable us to assess what the ground rent will be when the review takes place. On the issue of service charge, there was a case involving 89 Holland Park, a case that went to upper tribunal where the service charge for the year was over £420,000. Now, had you been buying a flat in that block previously, you might have seen service charge at £5,000 to £10,000 per annum, a lot of money. You certainly wouldn't have any expectation that in the 2022 service charge year, there'd be a service charge demand for over £420,000. The litigation was ultimately concluded in favour of the leaseholder, but I can imagine the leaseholder having one or two sleepless nights when faced with a demand of that nature. Important that clients understand that historical service charge information in accounts is not an indicator of what service charge will be going forward. Your client is committing when they enter into a lease to an obligation to pay service charge when, at the point of the assignment of the lease or the granting of the lease, your client will be unable to determine what the service charge will be in the future. We've got to watch out for lenders and CQS guidance. Remember the conflict of interest point that we made. Reviewing of instructions, a requirement to check lender instructions before we exchange contracts. And again, we've got to be careful to make sure that we're reporting to lenders issues with regard to the transaction. Complaint management. And again, I've been doing some work relating to this, quite interesting. When you're looking at file reviews or looking at feedback from clients, you know, everyone is keen to look at the positive feedback, the good news. But when you think about it, what is the benefit of someone telling you you're marvelous, other than waving it in front of partners or your line manager when you're talking about seeking an increase in salary, and apart from the sort of kudos that you derive from such nice positive things? But what benefit does the firm get? Surely the firm gets benefit from where there is criticism, hopefully constructive criticism, on the basis that if that criticism is well founded, then there is a step or there are measures that need to be taken to improve. So I think seeking reviews is important, encouraging reviews is important. Where there is negativity, drilling down to assess what that negativity is and seeing what can be learned from it is probably even more valuable. When we're onboarding clients, it's important that we undertake a risk assessment with regard to the client and the work. It's important that when we're engaging or taking on a client, we, in our engagement letter or in our retainer letter, we identify the scope of the retainer. Again, the case of Withers and Spire 2022 decision of the Court of Appeal highlights the benefit of having a robust scoping of the retainer when instructions are received, telling clients what we're going to do and telling clients what we're not going to do. Where there is vagueness or ambiguity, where the retainer is not clarified, there is vulnerability. The case of Withers and Spire that I just mentioned is a great case for highlighting the potential dangers of not scoping the retainer on receipt of instruction and being aware of the need to review the retainer as the transaction progresses. The next thing is to explain to clients so that clients understand what we're going to do and what we're not going to do with regard to due diligence, and also explaining the conveyancing process. Again, making sure clients get the gist of the process, the gist of the documentation, the gist of what we're doing, and significantly explaining to clients what we're not doing as well. Setting out service levels that we comply with. Again, I was talking to a firm last week on this, and that unfortunately, with a particularly difficult client, that said that, given what the client had said in the past with regard to the transaction, that this client would be taken out of the normal levels of service and would be provided with a special service, a willingness to respond to emails within 2 hours of receipt, for example, instead of the normal provision that a response would be provided within 24 hours. And again, that's dangerous. If you have service levels, stick to them. And of course, the opposite applies. And if you have a 24-hour turnaround with regard to emails, important that clients are aware that you will comply with that, or if there are circumstances where that's not going to be possible, the client is made aware of it. Making sure that we're SRA compliant with regard to our transparency relating to fees and estimates. Remember, our client is entitled to rely on an estimate or quotation that we provide to the client. We can only revise it if there's an objectively valid reason for doing so. In other words, what we're being asked to do is over and above what would be normally expected in connection with a conveyancing transaction. So someone was asking me last week, again, a co-ownership. Can I charge more for giving advice about co-ownership? Answer, definitely not. Can I charge a client more for giving the client advice when they sought it with regard to the standard conditions in connection with the contract? And again, the answer to that would be no. It would be expected that that would be ancillary to the conveyancing services that you'd normally provide. There are things that you can charge for. For example, if you're onboarding a client and you're assuming that your client is acquiring a registered title, and when the title comes along, you find out that in fact the title is composed of 3 registered titles, you'd be entitled to charge additional fees, as long as you make the client aware of the change in circumstance and the additional fees that you intend to levy. When we talk about scoping the retainer, it's so important, particularly given what we've seen in recent cases, in particular what we've seen with regard to advice relating to the Law Society concerning climate change just recently, that we make sure that the client understands what we're going to do, also what we're not going to do, and they understand and appreciate the limitations of work that we're doing. The fact that we're reliant on third parties with regard to searches, the fact that we're reliant on an environmental consultant producing an environmental search and report, the fact that the client will be relying on a surveyor or valuer, and we will be simply looking at a survey or valuation to determine if there are any issues of title that warrant examination. The retainer should explain that we're reliant on our client inspecting the property and reporting to us anything that is seen during that inspection. So I think the important point on slide here is highlighting the limitations with regard to the work that we do. I think that's so important. As far as highlighting the work that won't be done, again, setting out quite clearly the framework, the ground within which we will be exploring due diligence, and the fact that due diligence will not extend to the other issues. So we're not going to tell the client whether the deal is a good, bad, or indifferent. We're not going to tell the client our views, if we have any, about the state and condition of the property. Remember that we are required to provide advice and guidance and explanation with works that are reasonably incidental to the retainer, the works that are specified in the retainer. And remember the point that it is important, if we're going beyond the scope of our retainer, that we're telling the client that we're doing so, and again making sure that we're providing limits relating to it. So if, for example, we have a construction team or an environmental team that is giving a client advice about something ancillary to the conveyancing process, we need to make sure that there is a separate retainer for that work, and that we're highlighting and emphasizing to our client the scope of the transactional property lawyer's retainer. Where we are comfortable with giving advice on environmental issues, planning issues, etc., then again we could deal with that in the original retainer, or we could extend the scope of the retainer as and when necessary. The retainer should be in writing, and it should be in writing the moment the relationship with the client begins, at the start of onboarding the client. So it's the engagement letter, etc. It is possible for a retainer to be oral or implied, but I've mentioned to you already, both of those situations generate danger. The courts seem to be saying at the moment that where you've set out clearly what you're going to do and what you're not going to do, your liability, your risk for breach of contract or a claim in tort is limited to the boundaries of the retainer. The retainer should set out the work that you're doing, should also set out the work that you're not doing, and should set out where you're relying on third parties. Beware, as in all conveyancing drafting work, to watch out for vague or ambiguous wording in the retainer, on the basis that vague or ambiguous wording will be construed against you in circumstances where the courts are testing whether what you've said means that liability arises or it doesn't. Make sure that when clients receive the retainer, just as they receive an engagement letter or indeed a report on title, that they acknowledge receipt, that they confirm that they've read it and understood it, and invite questions so that the client can be challenged where the client at a later date says they weren't aware, or they didn't understand, or weren't aware of risk. You can say to the client, well, you've confirmed to me in writing that you received it, you read it, you understood it. I asked you if you had any questions and you said that you didn't. Again, important that you understand and appreciate that the retainer isn't the final say with regard to the duties that you owe to a client. You are also expected to do work that's reasonably incidental to what is included in the retainer. So there's the analogy with regard to going to see the dentist. You go to a dentist to show the dentist that you've got a bad tooth. The dentist is obliged to notify you that the tooth next to the bad tooth also has some issues or problems. He can't just simply, or she can't simply focus on the bad tooth and ignore the tooth next door. Well, exactly the same principle applies with regard to the retainer. The retainer needs to be managed and monitored. We need to be aware of the additional work that is required, and we need to avoid dealing with issues in connection with the scope of the work that we're doing in the report on title, because by the time the report on title is provided to the client, it is too late. The relationship, the contractual relationship, is already established. The next thing that I want to talk about is the issue in connection with overseas entities. And again, you know the legislation, it's in the notes in any event. All I want to highlight is a number of points. Firstly, if you're a conveyancing practice, residential practice, commercial property practice, or whatever, it's important to audit your existing clients. Are you doing work? Have you done any work for a client that is an overseas entity, a partnership or a company that's based overseas? And when we talk about overseas, that would include Ireland. Where that is the case, it's important that that existing client is notified of the need to register as an overseas entity, and that a failure to register will generate problems in connection with the conveyancing process relating to land or property in England and Wales. It is important also that when we're onboarding clients and taking on new work and new clients, again consider whether the new work or the new client involves an overseas entity, or where the client is an overseas entity. And it's imperative that where that is the case, we draw to the client's attention the need to register as an overseas entity at Companies House. Where that registration does not take place, a number of potential issues can arise. Firstly, where a party sells an asset and that seller is an overseas entity that isn't registered at Companies House, the buyer of that property will be unable to register the disposition at the land registry without the appropriate number that's allocated to the overseas entity that's required to be inserted in land registry documents. And secondly, as the seller of land or property in England and Wales that is an overseas entity that hasn't so registered also has the potential for criminal offences to be committed. So again, I'm not asking you to worry about verification of overseas entities. I'm not asking you to worry too much about transactional work. I'm just simply drawing to your attention the need to audit existing clients and new clients to determine if they are overseas entities, or where new transactions involve overseas entities, to make sure that that entity has been registered at Companies House. Where it hasn't, then alarm bells need to ring. If you look at the legislation and look at the regulations, there is a period of grace to enable companies to be registered and to enable partnerships, trusts, etc., to be registered. The whole idea sitting behind this is to prevent criminal activity and fraud being undertaken by overseas entities, and that fraudulent activity finding its way into the English property market. Talked about the retainer, and again, it's important that when we're assessing risk and determining taking on instructions, we consider overseas entities. We also need to, in our retainer, make sure that where there is an overseas entity, we highlight what that overseas entity is required to do or what we can do on its behalf. The retainer should also specify the work that we'll do for the seller and buyer, and should also specify what's excluded. I've given you details in the notes that accompany today's presentation. I think it's important that we set realistic expectation. I think it's important in 2022 that we learn that there isn't such a thing as a standardized process and a sort of a standard client, the client on the Clapham omnibus, as it were. That these days CQS guidance, SRA guidance, etc., guidance from professional bodies seems to be highlighting the fact that with regard to risk, with regard to understanding, every client is different. So it's important that we explain to clients what's going to be done. We explain to clients what's not going to be done. We receive information from our clients so that we can satisfy the SRA test of knowing our client. Again, I go back to that point that I bleat to practitioners on a monthly basis, the issue of client objective. Assessing clients' knowledge, assessing clients' attitudes to risk, appreciating that there's no such thing as a collective client. We need to be realistic as to our role, the role of third parties, and the role that the client has to play in connection with the conveyancing transaction. Going on a little further, as the transaction progresses, we do need to think about what happens if we amend the retainer to take into account additional work, and we do need to monitor it. The next thing I want to talk about is reporting on title, and again, this is an interesting area. During 2022, we've seen lots of firms producing electronic reports on title, which has done a number of things. In some respects, it's got the hackles up of conveyancers on the basis that the reporting on title function is something that I, as an experienced conveyancer, need to spend time on to make sure that the report on title is covering everything that needs to be covered, ensuring that it's personalized, highlighting client objective. At the other end of the spectrum, you've got firms saying that the idea of an electronic report on title is a brilliant thing. I sit somewhere between the two. I think an electronic report on title, or a template, because in essence, that at its heart is what an electronic report does, is very useful. It enables the report to be populated, potentially by artificial intelligence, enabling fee earners to check official copies of the register, check what's been migrated into the report on title already, as a sort of cross-checking activity. enabling fairness to sort of highlight or concentrate on issues that require manual inputs, making sure that when data and information migrates into the report, that we can then concentrate on making sure the report and the information within it is effectively communicated to the client. So I don't see the day where anyone will produce a product that means that the conveyancer doesn't have to undertake a sort of manual audit of the title. I think what we've got is a useful tool to assist us, not something that replaces us. As far as the report itself is concerned, it needs to highlight the due diligence process, highlight the conveyancing process, highlight issues, areas of risk with regard to what has been revealed in the due diligence process, highlight where there is the potential for further investigation, and to highlight where issues have been drawn to the client's attention, what the client's instructions are with regard to that issue. It is possible to have limitations and exclusions with regard to a report on title, subject to what I said earlier about our due diligence and our identifying the scope and extent of the retainer, and the fact that we are obliged to do work reasonably incidental to that retainer. But certainly, for example, we should be telling clients that we'll provide them with a land registry title plan, but they can't rely upon it. That there may be issues relating to the title that they are acquiring that are not revealed by official copies of the register or the epitome of title that the seller has produced. We go back to my old friend, the overriding interest in that regard. We should be explaining to clients that when we're undertaking searches, those searches are being provided by third parties, such as local land charges departments and such as the land registry. And both may from time to time make errors, that there is the opportunity to claim an indemnity in such circumstances, but there is a risk that our client is bound by, for example, a local land charge that isn't recorded on the local land charges register. Again, this point really harks back to what we said earlier about setting realistic client expectation. On the issue of reporting on title, there's loads and loads of case law which confirms a number of key points, most of which have been sort of refined or repeated in the case of Spire Property Development and Withers, albeit a commercial property case. The important thing with regard to these cases is as follows. The mantra of information, explanation, and advice needs to be tuned so that when we talk about advice, we're highlighting to clients risk. We're not assessing, determining, or quantifying risk. We're just drawing to our clients' attention that there is risk. It is then the client's call what they do. They either undertake their own assessment of the risk via instructing third parties, surveyors, environmental consultants, structural engineers, whatever it may be, or they instruct us to investigate the risk on their behalf. Again, it's important to understand from Moda and Minkin and AW Group against Taylor Walton that this isn't a requirement that you as a conveyancer are an expert in planning, environmental issues, construction issues, or indeed anything else. Your task is simply to perform the task of a reasonable conveyancer, and as far as that is concerned, a reasonable conveyancer would highlight to the client risk or vulnerability. That risk or vulnerability could be an adverse entry in a search, as we saw in Orient Field Holdings and AW Group. It could be highlighting to client the limitations of the conveyancing process and or due diligence. It could highlight a potential problem or issue in the conveyancing process. Where we have a particularly risk-averse client, then it might be necessary to highlight to the client what can be done in order to reduce or minimize the effect of that risk. Again, we've spoken in the past, haven't we, this year, about seller identity fraud in that regard, and explaining that Stewart Title has a product that deals with the issue of seller identity fraud. Again, for a risk-averse client, that's a great product that protects the client from the risk. The next thing I want to talk about is leasehold and leasehold reform. 3 points important. Point number 1, Leasehold Reform Ground Rent Act 2022 abolishes monetary ground rent, but it does so not retrospectively. So we've now got a two-tier market. If I take an assignment of an old lease, there will be a monetary ground rent payable. If I acquire a new flat from Persimmon Homes, then that new flat will not have a monetary ground rent, but will in fact have a peppercorn, meaning that we've now got a dual market. Significantly, where we're extending leases, and we're extending leases by agreement, the regulations prescribe that the monetary ground rent can only remain for the remainder of the existing term. The portion of the lease that is extended has to have a peppercorn ground rent, as would a new lease. The significance of that is we've now got a dual market. So if our client is taking an assignment of the lease where there's a monetary ground rent, the client needs to understand that that might have issues with regard to valuation or marketing purposes going forward. Where we've got new leases, it's important to check service charge provision, because landlords might hide the ground rent cost within service charge. On that point, there's an interesting issue to explore, namely, if you look at the consultation during the passing through of the Leasehold Reform Act 2022 in Parliament, a lot of landlords, when making contributions to the debate about the proposed reform, was saying that ground rent was revenue that they would utilise to support or back up service charge. It was sort of a hidden fund that could be called upon where leaseholders were unable or unwilling to meet service charge. So when I saw that, I thought, what landlords are doing here is they're lining up the fact that they're losing revenue, and perhaps suggesting that it might be possible to create within service charge a fund to cover that shortfall, a sort of reserve or sinking fund to cover unpaid service charge, perhaps. So just watch out for that. The Building Safety Act 2022 is a radical piece of legislation that does two important things. First of all, it creates the role of a building services regulator, and ancillary to that, a whole raft of new documentation that will be produced relevant to building safety, that landlords or managing agents will be utilising. That information will be coming from the building safety regulator with regard to risk assessments, etc., and will also involve reports being submitted by the owner of property to the building safety regulator. The Building Safety Act creates a new duty and a new series of duties and obligations with regard to higher risk buildings, buildings that are more than 18 metres in height or more than 7 stories in height. Important also to understand and appreciate that there are now implied terms into residential leases, notably implied terms with regard to the landlord being obliged to comply with the Act with regard to safety measures, and obligations on leaseholders to pay building safety charges. The Building Safety Act potentially generates a whole raft of documentation that will be useful resources for buyers of leasehold property where the leasehold property is in a higher risk building. And remember, with regard to leasehold transactions, we need to provide explanation and advice. So the lease, we explain to the client the gist of each and every term. Service charge, we explain to the client what the service charge provisions are, what the service charge accounts reveal. And again, it's not just a question of giving the clients the service charge accounts, but explaining to the clients that specialist advice might be required from surveyor or valuer with regard to service charge costs, or with regard to the accounts themselves, specialist accountancy advice. That clients need to understand that just because we've got 3-year service charge accounts, that isn't a fair indicator of service charge going forward. With regard to advice, we've got to highlight to client risk. So I've mentioned already, service charge. We're committing to an ongoing expense that we don't know. Escalating ground rent reviews in leases. Our client is committing to a ground rent going forward that could be reviewed, and we can't assess what that review will actually involve. It's this sort of thing that I think is so important with regard to leasehold. The SRA have been warning us from 2017 The CQS guidance in 2022 sort of highlights or raises this as an issue once more. We need to be alive to it. Again, there's an important point to note here, going back to what we said about reporting on title. If we start having to do all this additional work with regard to leaseholds, that's going to expand the content of a report on title. So we need to be smart or smarter in connection with how we provide information. So perhaps when we're onboarding a client and providing an engagement letter or we're scoping the retainer, we can highlight to clients the fact this is a leasehold transaction and drip feed the client as to the consequences relating to that. Again, recently, I've been talking to people, and one firm in particular that was telling me, this was in the Southwest, about the fact that when they're taking on board a new leasehold client with a leasehold acquisition, one of the things they're concerned about is whether the buyer client has pets or intends to keep pets, and to highlight that in most residential leases, the keeping of pets is limited or in some cases prohibited. And again, I adopt the same strategy with regard to Airbnb letting, right at the start of the transaction, highlighting to clients that in most cases, leasehold ownership will preclude Airbnb letting going forward. In the notes, I've given you some case law relating to administration charges and service charge in residential leases. I don't have time to go through that today, but also I've given you a very sad story of about an unfortunate solicitor that found himself before the SDT in connection with a sad transaction. I mentioned in my introduction, this was a firm and a firm that was willing to accept instructions at the start from a seller and buyer in connection with a transaction. Quickly realized that it would be impossible to continue to act for both parties, but continued to act for the seller. Never met the seller. Was aware that the buyer was an accountant who was buying the property at a severely discounted price. It transpired that the buyer was an accountant that was using funds that fell foul of the money laundering legislation in connection with the purchase and had exerted a type of undue influence over the seller. The seller was an unfortunate soul who had problems with regard to mental health, had an intelligence age of approximately 14, and who was taken to the cleaners and back by the buyer in connection with this transaction. When you read the SDT decision, it's amazing to see just how problematical the fact that this client wasn't seen and an assessment made of the client's well-being led to all manner of problems. The reason I mention the case is threefold. One, the dangers of acting for two parties. Two, the additional dangers of not seeing clients or meeting clients and getting to know the client. This important point about assessing client objective. Why was this chap selling the house? What was this client's state of knowledge with regard to the transaction? What was this person's attitude to risk? All of those things weren't properly assessed, if at all. There's another matter before the SDT just recently, which again was interesting, scary too. A firm where a fee owner was fined, a solicitor was fined £10,000 for submitting over 100 reports on title to clients in a leasehold development, where the firm had established a standard form of report on title for leases on that development, not appreciating that partway through the development, the landlord had changed its leases, in particular with regard to ground rent provision. And the report on title in connection with 100 or so cases that were sent out to clients after that event did not record the change with regard to the ground rent. Not only was the firm liable in negligence to over 100 potential claimants, but the firm themselves was fined £10,000 by the SDT on the basis that this was professional misconduct. Again, it highlights the point that I think has been frequently observed throughout 2022, that standardization, computerization, case management systems are brilliant, but at the end of the day, we're dealing with individual clients. and that we need to be aware that for every report on title, for every engagement letter, for every aspect of due diligence that we're undertaking, we're undertaking this work on behalf of individuals that have different needs, different expectations, and different objectives. On that happy note, Stephen, I'm going to finish and say it's my favourite time, question time. Before I do that, Robert, with regard to product, is there anything sort of in the pipeline with regard to Stewart title that I'm not aware of, or perhaps that attendees today might be aware of? Is there anything on the website or anything coming on the website with regard to product or changes or anything that people need to understand?
We do have a couple of projects we're looking at the moment, and actually it might be useful for feedback, not in this forum, but for people to email us on the interest in a reduced due diligence good title policy, which we're looking at the moment, to see really what lawyers would want support from a policy there. It's not to take the bread and butter out of lawyers' mouths, but to see if there is an insurance product there that could support them and give them comfort, and perhaps even give their PI insurers comfort. So that's something we'd be interested in knowing about. And we are in the early stages of looking at a policy that might give comfort to lawyers who are engaged in trying to sell or remortgage a property which is still stuck in the course of first registration, which we know from your talks and from conversations with lawyers is still a problem. So both of those might be forthcoming, and certainly interested if anyone's got any views on the need for those policies. That'd be very interesting to know.
Yeah, I think that's a great point you make, Robert. The fact that you have standard products sitting there, but again, if lawyers have a need or a requirement with regard to product, it's an open door with regard to having a look and seeing if there's something that could be designed for them, or perhaps even a new product that's of general significance or consequence. So thanks for that, Robert. Stephen, question time. What have we got?
Absolutely, it's a bit quiet on that front at the moment, Ian, but I'll leave it open for another minute or so. So just as a reminder to everyone, you can still submit questions through the questions pane in your attendee control panel. So as I'll just let that run for a minute, we did have another poll, Ian, so I might just run that while we're waiting there. So this poll is: what do you see as the main danger for the property market in 2023? And it's interesting, really, that because the land registry delays does come into this as well. But the four options are the lack of properties being marketed, the cost of living, mortgage rates and availability, and land registry delays. So I'll just leave that run for 30 seconds and just see if there are any further questions that come through.
Yeah.
So we had a question earlier on. I think this is really just a clarification, to be honest, just in terms of the terminology used. And Charlotte asks, would a retainer be a terms and conditions sent to client for signing upon onboarding? So I think that's just clarifying the terminology of retainer there.
Yeah, thanks, Stephen. Charlotte, it's a good question. It could be. Depends on whether your terms and conditions are being specifically detailed in telling the client what you're going to do on their behalf during the transaction. Okay, so when I talk about the scoping the retainer, it's telling the client that I will be considering the documentation that I receive from the seller's conveyancer, the contract, the evidence of title, etc. I will be performing the following searches on your behalf. I will be considering the TA forms that have been produced by the seller. So it's listing the transaction and explaining to the client what's going to be done and what's not going to be done. So Charlotte, if your terms and conditions are explaining all of those things, then we're talking about one and the same. If your terms and conditions are just that you can only remit monies to our client account via bank transfer, and we will require sources of funds, we will require you to provide evidence of your identity, or we'll use a client verification system to verify ID. If your terms and conditions are listing when your communication policies, or so we'll respond to emails within 48 hours, we'll respond to telephone calls within 4 hours, or whatever that is, their terms and conditions, that's not the retainer. I'm doing some work actually on this because again, I think it's something that some people are not aware of. I would class it as sort of the old-fashioned engagement letter, Charlotte. So, setting out what I'm going to do for you and what I'm not going to do for you. So I can't, unless I see your terms and conditions, I can't give you a definitive answer, but I hope I've sort of shared with you what the expectation would be in connection with the retainer and how you scope the retainer. Any other questions, Steve?
I think that's a really useful answer. Thank you, Ian. Yeah, we have one more question in from Joe, and Joe, just again, a sort of clarification here, asks, are companies registered in the Isle of Man classed as overseas entities?
Yes, they are.
They are, perfect. Ian, before we log off there, I don't know if you can see on your screen the results of the poll there. Perhaps not too many surprises there. I think that's how I seen it falling. I was at an event recently, and they were saying that the difference, this is going back 3 or 4 weeks ago, but the difference there was that instead of 20 people bidding on one house, you were now seeing 3 or 4 people. So that points maybe a bit to the lack of properties being marketed, but maybe not being such an issue because of that reduced demand. But any sort of thoughts from yourself on that, Ian?
No, it's again, one of the things I think is that, when you're constantly faced with the news and its gloom and doom, and the cost of living in interest rates, etc., I think we sort of beat ourselves up, don't we, about it? And sometimes, my view is, well, life goes on. There's still people that are relocating with work. There are still people that are being moderately successful and buying up market. There are people that aren't being so fortunate and are downsizing. So I think there's always a base level of work. And I think one of the other problems that we've got is we've had it so good, haven't we, as conveyancers and as people providing services to conveyancers, had it so good for 3 years that perhaps we don't remember what normality was. And perhaps what we're seeing is a sort of a cutting back towards more normal times. And therefore, yes, it's nowhere near as good as it has been, but then it has never been as good as it has been either. So I think it's this sort of trying to remember what normality was. So to be honest, Stephen, I'm fairly optimistic. I think, next year is going to be hard. And there's no doubt about it. Cost of living, fuel, etc. It's horrendous and horrible. But there will still be people that will want to move, that have the aspiration to move, and that will be able to move. And that base level, I'm confident, will remain throughout the year, and it will provide work for conveyancers. Not the same volume of work. There won't be the same sort of cut and thrust that there's been, but I still think there will be some. I just hope that the downturn, and there is a downturn, no doubt about that, isn't as deep as it has been. And I'm hoping that, as people are saying, it's sort of relatively short-lived, in which case, hopefully 2023 we see a sort of redressing of the balance, and then 2024 we get back to sort of what I would class as sort of better times. But certainly that poll's really interesting, Stephen. Thanks for that.
Absolutely. And I think we'll wrap it up there, Ian. So thank you, as always, for your time today. Thank you for that nice positive message at the end as well. Thanks everyone for attending. That just leaves me to say, I wish everyone a happy end to 2022, and thanks everyone again for joining. Speak to you soon now. Bye bye.
Thank you, Stephen. Bye bye.